Welcome back to Kapowich on Real Estate. This is a program dedicated to consumer protection within the residential real estate arena. We used to call it risk management 200 shows ago, which reminds me, in I don't know, show 1, 2, or 3, we had David Hamerslough, real estate attorney David Hamerslough on the show. He's here tonight. Roger Wintle is back in the studio. These fellows represent, Roger, you represent, among other players, the Santa Clara County Association of Realtors.
Yes.
And Dave, you represent the Silicon Valley Association of Realtors.
That's correct.
I actually called the San Mateo Association of Realtors, and they don't have an attorney. So we are pleased to have, I'm a member of both boards, so I know the membership is strong. I've always thought it seemed like the Raiders and the 49ers, or Apple and HP, they operate in a different fashion in terms of their paperwork or standard of practice.
Well, we do have two different contracts that
right.
most members of each board utilize, but standard of practice, I would hope, is the same.
Okay.
I would hope too.
Okay. That brings up a good point. You are on this forms committee for the local forms, and you recently redid the contract as we know it here locally. Didn't you chop it up one Christmas?
I did with a dear colleague and friend, Vicki Nadorf.
Right.
I spent a day or two with a pair of scissors, taking the original contract and putting it in a different sequence.
Right.
And it was a lot of fun. It was a pleasure working with Vicki, and we also came up with a San Mateo County and Santa Clara County advisory, which was an effort to assimilate any number of various disclosure forms and advisories and a number of ones from various companies to try to come up with one document, so that buyers and sellers could go to one source to obtain information relative to the transaction.
Okay. Because this show airs from San Jose to South San Francisco, so we do have different associations up the peninsula that use the PRDS form, Peninsula Regional Data Service. Now, Roger, the board that you represent, Santa Clara County Association of Realtors, they use the California Association of Realtor forms.
Correct.
They're statewide, and they have their own checklist, their own disclosure forms.
They do, and they also sometimes use the PRDS checklist as well, which I think is an excellent checklist.
Right. So let's talk about some of the issues that are happening out there. You had mentioned before where buyers would write an offer and state it's all cash, but really they do need to get a loan.
Well, I think what's going on, Dave and I were talking about this morning, there's two real estate markets. There's the REO and the short sale market, and then there's the regular market that we're all used to. And in that regular market especially, there's so little inventory out there right now that when a house goes on the market, you're probably going to get multiple offers. So buyers have learned that if they're going to be in the game, if they present an offer that has a financing contingency and an appraisal contingency, sometimes if there are multiple offers, they're going to get thrown in the trash can. So what they do is they offer all cash, knowing full well they need a loan and that the property has to appraise in order for the loan to be approved. So they're playing that game, which is somewhat unethical from certainly the real estate agent's standpoint. But you can understand for somebody who really wants to get into a house, they've been bidding on houses and they keep getting defeated. They just start playing the same games that other people are playing, which is to make the all cash offer.
So Dave, the word gets out there with the public and the agent saying, if I want to get this house, I have to say it's all cash?
Well, not only perhaps all cash, but non-contingent. Mm-hmm. So the effort to make yourself the most appealing to a prospective seller, including cover letters with, we're still in that type of environment. But Roger, we were talking this morning, and it's really price sensitive and neighborhood sensitive.
Sure.
I mean, the days of multiple offers are definitely back in a number of areas and a number of price points. We were talking about that you still have investor purchasers who are all cash. And one of the keys, either as a buyer or as an agent, is understanding the market, understanding what your expectations are, as a
Right.
buyer,
Right.
trying to meet those expectations and realistically doing so given the competition that is there.
Now, you mentioned contingencies. Roger, contingencies, if you can explain for the lay people, how does a contingency work in a real estate transaction?
Well, there are a number of contingencies in any type of contract. The contingency just means that you have to be satisfied that you can perform whatever the contingency may be. For instance, if you have a financing contingency and you want to get a loan at, say, 4% interest, 30 years fixed, and you can't get that 40 or 30-year fixed at 4%, then you have the right, as long as it's within the time frame of the contract, to terminate the contract and get your money back, because it's
Right.
contingent upon your being satisfied with the financing. Appraisal is the same. If the house doesn't appraise, you're not getting a loan, so then you'll want the right to terminate the contract and get your earnest money deposit back. And then there's all kinds of inspection contingencies that you can ask for. You can have a roof inspection, you can have a property inspection, you can have a termite inspection, a foundation inspection, etc. And if you're not satisfied with those inspections, as long as you're acting in good faith, you can terminate the contract. But as Dave said, what we're seeing in the market now is sellers don't want to see contingencies. They want you to be locked in from day one.
Right.
They want all cash, no contingencies. Here's the inspection reports that we did. Take it or leave it, and you're buying the house as
Okay.
is.
See, that's a good point, Dave. You had your firm, Rossi, Hammerslough, Reischl and Chuck, had a training arm years ago, and
That's right.
you seem to think, the theme, it seemed to me, that contingencies are good for sellers. And that's what I try to convey to everybody when I present an offer to the seller and the seller's agent, that it's in their best interest that my buyer does inspections and has plenty of time to sleep on it and walk away from the transaction. So these sellers and their sellers' agents who are insisting almost, or gleefully accepting offers that are non-contingent, the buyer doesn't do any inspections and relies on their disclosures and theirs inspections, that doesn't seem like a bulletproof file for the seller, to me.
Well, we've touched upon several things. First of all, we're assuming, the three of us, that we have upfront disclosures.
Right, exactly.
Meaning, a completed transfer disclosure set, typically a supplemental disclosure of one or the other, either a seller supplemental checklist or a seller property questionnaire if we're using the CAR forms, and that we have a set of reports and all of that being provided. What I've learned in my years, and I'm sure Roger can echo it, is that really depends on the geographic area where a transaction takes place. It's not really driven so much by price, price point. It's really driven by how agents in particular areas handle that. I've always been a big supporter or believer in that. When I've sold my own property, I like to know what I'm selling, and I like to have it fixed with clearances. And then if somebody wants to come in and inspect themselves, I'm all in favor of that. And getting back to what we're talking about, I do like to see sellers give buyers the opportunity to inspect, even if it's for a shorter period of time than perhaps a normal contingency period would be. There is an argument that's been circulating out there in our world for a number of years as to whether or not the as-is clause is jeopardized or enforceable in the event you don't give the buyer the opportunity to inspect the property.
Oh, interesting.
With or without a contingency. So you still have the right to inspect, but you don't necessarily have the right to back out of the deal without that contingency. Right. And to follow up just a little bit on what Roger was saying, you certainly have an implied covenant of good faith and fair dealing, in terms of all of these issues. And I know that I'm seeing deposit disputes at this point over, did somebody apply for the loan designated in the contract? We were talking about coming in all cash and then really trying to get a loan.
Right.
And having that dilemma. We've certainly always had the issue about property inspections and whether somebody is backing out for a purely subjective belief.
Okay, that's a good point, because I think if sellers set themselves up, if they have what you mentioned, have a disclosure package, and that's typically West Santa Clara County and parts of the peninsula. The seller, before the sign is on the lawn, has a roof inspection, chimney inspection, termite inspection, home inspection, perhaps some repairs, documentation of the repairs, and then all the questionnaires that a seller could fill out, has it on the kitchen table, has it on the internet, and then puts a sign on the lawn. And the buyers come along, they know what they're buying. So the chances of having a transaction fall apart later and a fight over a deposit has been greatly reduced.
Well, even more importantly, I think what I see, and I'm sure Dave does too, is some of the biggest disputes are the disputes over non-disclosure issues.
Right.
And if you don't have a chance to really thoroughly go through the documentation in order to satisfy yourself as to what you're buying, and ask the questions that need to be asked. I mean, we have a saying that if you have to ask a question about whether you need to disclose or not, you know the answer.
Right.
Disclose,
Yeah.
disclose. Yeah. And I get these cases all the time where somebody said, well, they didn't tell me about this. And I buy the house, I find out something's wrong, and then we're in a fight. It might be a $25,000 fight, it could be hundreds of thousands of dollars worth of dollars at issue.
Yeah, now Dave, isn't it true that, I shouldn't preface that statement to an attorney, right? Isn't it true, sir, that the seller often says, well, if somebody asked me, I would have told them. I didn't think it was that big of a deal.
Well, that's one of the risks of imposing your subjective beliefs,
Right.
and assuming that they are consistent or the same with every buyer's. And I think we have language in a number of the various advisories that we've talked about the potential risk of doing so. Just like in any transaction, whether you're representing a buyer or seller or are the buyer or seller, if you make an assumption and the assumption turns out to be incorrect, then it potentially can lead to some accountability.
Now, there has to be some honesty. I remember I went to closing arguments, a young attorney we spoke about before the show, and there was the realtor and the seller spent an hour answering one question: does the roof leak? Or something like that. And they were trying to wordsmith it, right? And they had some fancy language that at times of climate change, some condensation may appear. Well, it leaked on the dining room table and leaked on the master bedspread, different ends of the house, $125,000 in damage. That was back then when a roof inspection was $65. The buyer didn't get a roof inspection, the seller didn't get a roof inspection. And of course they move in, and then the neighbors come over. Some of the vendors they called out had already worked on these leaks. So filling out these disclosures, it's prudent to be sitting with a realtor when you fill them out, or agent, right?
Absolutely.
And to do them honestly.
Do them honestly and thoroughly. People sometimes try to hide the ball. They'll tell you about a problem, but they'll only give you enough that you might say, well, that doesn't sound too serious.
Right.
And they'll give you the full picture.
Right.
And then they'll use that argument, well, you should have asked. But you have a duty under the law to disclose all material aspects that might affect the buyer's decision to buy the property. If you don't, then you're going to suffer the consequences if there is a problem.
And I've seen Dave speak probably more than anybody, and you had in the past mentioned agents. Realtors, agents have to walk the property and describe what they've seen. And you would always advise that agents should describe what the crack is. A small crack due to settling. An agent probably isn't qualified to say small or minor or any of that, just crack in driveway.
Try to steer clear of adjectives or conclusions or opinions.
Right.
But my comments about disclosure, if I'm a seller, is slow down, take your time.
Sure.
Those disclosure forms ask you for a lot of information. They are cumulative. They ask you whether past problems existed, even if they've been repaired. And I think a great piece of advice for a seller is pull out any records you have about the house, put them in chronological order, and do the disclosure statements in conjunction with those historical documents, because what will invariably happen in a lawsuit is the first thing the lawyers are going to ask for is, please give me all of the documents that you have.
Right.
And the worst thing is when there's this folder, that was sitting there, and the seller says, well, I had this all the time, but I didn't pull it out, or nobody told me to pull it out.
Right.
And then you, of course, have factual disputes about whether people were or were not aware of those things. But the other thing about those forms is they really contain multiple questions within each question. They're set off by commas, or they're in the disjunctive, the conjunctive, and you got to be very careful. And we on our PRDS Forms Committee just revised our supplemental checklist to try to address some of those issues, because one of the things, Roger, that I was seeing is you get a question that's answered yes, but there's really multiple subparts within the question. There's no explanation, as to what you're answering yes to, or what's happened historically. And I'm also a big believer in if you have those records, there's no harm in making them available, to the buyer as part of a upfront disclosure packet.
And by keeping all those disclosures available, especially as the market slows down, sellers and the seller's agents say, oh, well, they didn't want to pay for any reports. And oftentimes the agents get a little lazy, so I don't want to sit down at a kitchen table and do these disclosures, so we'll wait for an offer. And that's when one of my mentors used to say, what are you going to do, surprise them after they buy the house? When they have buyers, a little anxiety there.
But one of the points that you made is the duty of the agent to do a visual inspection of the property. And I've seen a lot of agents who get real lazy, and they'll put in the comment section, see reports. Basically, I'm not going to look myself.
Right.
You go ahead and read these reports. Well, that's not your duty is to actually do a visual inspection. You're not a contractor most of the time, and you don't have the expertise, but you certainly have a lot more knowledge about what things look like in a house than the average buyer and seller, and you do have a duty to look. And those people who see the reports, I mean, they have a hard time explaining why they really didn't walk through that house and do an inspection and protect their clients.
Okay. It seems to, I go to a lot of seminars held by attorneys, and I've been speaking to attorneys forever, and they seem to think that most of the lawsuits that are filed, it's a buyer going after a seller. And most of those cases are called a bad house case or of disclosure issues.
Non-disclosure bad house case.
Yeah, I would agree.
So in that case, working backwards, how can a seller avoid that? So we've kind of touched on it, but they could fill out the disclosures, have them available, have inspections.
And I think they have to think through these disclosures when they're filling them out. Sometimes if you've lived in a house for maybe a long period of time, say 10, 15 years, and something could have happened 5 or 6 years ago, and you think, well, I took care of that. There's no harm in telling the buyer, we had the roof leaked, we had it repaired, here are all the documentation to show the roof repair, instead of just saying, well, we had a roof leak and it was repaired, so I don't have to tell them.
Right.
You might be able to get away with that, but if that roof leaks after the buyers move in, they're going to wonder why you didn't tell them to begin with. So I think that's a really good point.
And I had heard from some of the attorneys in Dave's office that when he was selling his house, he had a yellow pad on his nightstand, and when he thought of something, he'd write it down, which is a good point, because, and I probably got that from your seminars years ago, is disclosure should be filled out at the house with an agent, not at a real estate office, right? So you can get this memory hook or maybe walk around the property.
Yeah, I mean, I've experienced the following in looking at a lot of TDSs and supplementals over the years. Number one, all of us, over time, come to accept the deficiencies and idiosyncrasies that our houses have. I know my wife certainly accepts my deficiencies and idiosyncrasies over time. And that happens, and you forget about things. What might be annoying or an issue for a purchaser, because of the passage of time, you just sort of have accepted. And so it is helpful to have your memory jogged. That's why I'm a big believer in not doing these on one sitting.
Right.
And yes, I did have a sheet.
It was true.
That was true.
This is a book.
Oh, you guys, I mean, I can laugh, but I mean, my disclosure on the last house I sold was a TDS and a PRDS seller supplemental checklist, and then I think it was 8 single-spaced pages attached to that. And I'd only lived there 4 years.
There you go.
Now, am I a little sensitive?
Right. And of course, the buyers, that's what buyers appreciate that, and they feel, hey, that person was fair and square with me, told me everything.
You know what's funny is, of course, one reaction to that is, oh, you're going to scare everybody away. The other reaction is, no, just what you said, Pat, which is, no, a buyer is going to look at that and think, wow, I'm getting a lot of information. As opposed to, we've all seen a disclosure document where you get basically no's. You know, you could take a ruler out, you know, down the column of no's. And, you know, it's just important to appreciate the history, no matter what amount of time it's been, no matter whether you personally don't think it is relevant anymore. It may at times be relevant, you know, or material to a buyer. I mean, I'm sure Roger does too, any number of these cases going right now over either what somebody says didn't happen or their recollection of what event did take place is far different in perspective than what the buyer may now be experiencing. So we ask ourselves, what accounts for that changed view? Is it truly a different phenomenon that's taking place? Or, you know, is it the same thing and somebody is, you know, for whatever reason, recalled it in a different way?
Now, in terms of the inspectors, we're talking about disclosures, but it's important for I believe, the buyers and the sellers, whichever party hired them, to be on site when they're going through the house.
I think that's helpful. I just wanted to make another point here, is I've had a number of cases where the buyers will say, the sellers will say that the agent filled out the inspection reports, the TDS and supplemental. You know, any of this and any of that, and they're marking the box. A big no-no for an agent. Right. That seller has to own those disclosures. They're the ones that know that house.
I thought the seller is in a hospital bed. The seller has to still do it in their own pen.
I would prefer that.
Right.
You know, another thing that I've noticed is if you go over a disclosure document and you run into a question which you're unclear about, many sellers will either put a little bullet point, you know, just a little pencil or pen point out in the margin, or a little question mark or a little check, because they want to stop and they don't know the answer, and then they go on. And it is important to make sure that somebody goes back and takes a look and says, look, we've got questions, or excuse me, answers to all of the questions, and then, you know, most forms require that there be an explanation for any yes answer. And Roger touched on this earlier about, you know, what is the level of detail, you know, in that answer, you know, in that explanation.
Right.
And you know, that's a common source of dispute.
And it also allows the buyer or the buyer's agent to ask some questions. Hey, I see you had a leak here last winter, but you said somebody fixed it. Might be, what company fixed it? Do you have a receipt?
You have a receipt, you have the contract, is there any warranty that's still out there? Those are all good questions to ask.
So in terms of those inspections, by the way, if you do have inspections, it's a good idea to be on site rather than wait for it to come over a fax or online. Because it's a different experience.
Yeah, I think that's absolutely correct.
Okay.
Yeah, Pat, I definitely, when I'm reviewing a file, I was looking at one before I came over here tonight. I happened to notice that the buyer was not present, you know, when the inspection took place. And that, you know, sends a signal to me, why wasn't that happening? If this is your primary inspection,
Exactly.
that you're getting. I mean, I don't expect anybody to crawl the house with the pest control operator, but it's important to be there.
I've always said that the buyer is going to know the property better than the seller. If the buyer's on site on a roof inspection, chimney inspection, home inspection, termite, by the time those 4 are over, that buyer knows the property better than sellers.
Well, let's also focus on follow-up inspections. I mean, we're again
Right.
assuming that you have a contingency, but even if you don't, you can still do these inspections. You just,
Sure.
But remember, these reports are going to identify at times potential issues that may or may not need follow-up. You have to realize that the perspective of the people writing the report they're trying to make sure that they fully disclose what issues they think need follow-up, and
Right.
buyers need to follow up on these things. Sure. Look at this.
Here we go. Here we go. Thank you, buddy. This is my nephew here, Buddy Kirby.
You're welcome.
We want to thank Roger Wintle, Dave Hammerslough, being here at show 200. And in fact, Dave was here on show 100.
I was. Pat,
Yeah,
thanks
yeah.
for having me. Congratulations.
Yeah.
And I will be here for
Show 300.
250, 300.
Don't wait so long next time.
Yes, congratulations. That's quite an accomplishment.
Great, thanks. I hope you guys can stick around for some carrot cake. Thank you, sir.
No problem.
All right, so we got to wrap it up. So we have any key points here from Roger Wintle?
Well, I think we touched on a lot of things. I think, again, the most important from a seller's standpoint is disclose, 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 and then you won't have any subsequent problems, or you hopefully won't have any subsequent problems.
By the way, we talked about the 2 markets with the home bank-owned and short sales. When those started to come, the agents, you'd call an agent to speak to them and they say, do not leave a voicemail. If you have any questions, you email me. That would be the instructions on the outgoing voicemail. So now the communication just got shut down. I always thought it was just communication, communication, communication.
Well, you're talking about REOs?
REOs and short sales. So now we're wrapping up. How many more seconds do we have here on show 200? This is Pat Kapowich, Silicon Valley Association of Realtors attorney, David Hamerslough, Santa Clara County Association of Realtors, Roger Wintle. You have your own practice, of course, and we appreciate you coming out here on tonight. Thanks again. We will see you on show 300.
Thanks, Pat.